Hello, my name is Rena Kim, and I am the president of the Korean American Bar Association of Washington, D.C. Thank you all for joining us today, the last day of Women's History Month, to talk about the history of the comfort women who served the Japanese Imperial Army before and during World War II. This topic is particularly timely in this charged climate of anti-Asian hate, but more specifically, in the immediate aftermath of the horrific shootings in Atlanta earlier this month that took the lives of 3 people, 6 of whom were Asian women, as well as continuing violence against Asians. Now is the right time to talk about violence against Asian women.
Hello, my name is Christine Hahn, and I'm also on the board of directors of Cal-APABA DC. The genesis of this panel came from an article by a Harvard law professor that rewrote history on what some scholars have called the largest case of government-sponsored human trafficking and sexual slavery in modern history. The professor characterized this as a free market economy, compelling girls and young women, as young as 12 years old, to seek their fortunes and enter into voluntary contracts to become prostitutes.
Brian, you need to unmute.
Pardon me. This offensive regurgitation of right-wing Japanese propaganda was given credibility by the professor's lofty perch at Harvard Law School and does violence again, both to the remaining individual comfort women, many of whom are in their 80s and 90s and have never seen justice in their lifetimes, and to those of us who convened this panel, reigniting a shared national and human trauma. My name is Brian Byeong, and I am past president of CAPA San Diego and our national coalition of CAPAs, the International Association of Korean Lawyers, and the Korean American Association of Greater New York refuse to sit idly by and let this false narrative gain any kind of toehold in our society. To lead our discussion today, we are so happy to have with us Jeannie Suk Gerson, the John H. Watson Jr. Professor of Law at Harvard Law School, where she has taught constitutional law, criminal law and procedure, family law, and the law of art, fashion, and the performing arts. Before joining the faculty in 2006, Professor Suk Gerson served as a law clerk to Justice David Souter on the United States Supreme Court and to Judge Harry Edwards on the U.S. Court of Appeals for the D.C. Circuit. She earned her bachelor's degree from Yale, her doctorate in philosophy at Oxford, where she was a Marshall Scholar, and her J.D. from Harvard Law School. She has written 3 books and many articles in scholarly journals and general media, including her most recent article in The New Yorker, Seeking the Truth About Comfort Women, which was the initial impetus behind the organization of this panel today. Professor Suk Gerson.
Thank you so much. I am really delighted to participate in this event called The Importance of Truth, Comfort Women and Beyond, and also to be in discussion with my wonderful fellow speakers, Tessa Morris-Suzuki and Norman Eisen. The composition of this panel is a bit like the setup, where you have a lawyer, a historian, and a diplomat who are trying to figure out how to screw in a light bulb. Well, if the light bulb represents truth, it is clear that each of our disciplines is going to approach that somewhat differently. Let me introduce each of the other speakers before making some remarks myself, and then moderating a discussion amongst us, and eventually incorporating questions and comments from other participants in this session. Professor Morris-Suzuki is a professor emeritus, professor emerita of Japanese history at the Australian National University. She is an esteemed and prolific scholar, the author of multiple books, including 2 just published in 2020 alone on the frontiers of history and Japan's living politics. Her research interests include national identity and ethnic minorities in Japan, human rights, globalization, memory, and reconciliation in Asia. And she is joining us from Australia today. Thank you, Professor Morris-Suzuki, for joining us. We also have with us Ambassador Norman Eisen. He is a senior fellow at Brookings, and a widely published expert on law, ethics, and anti-corruption. He most recently served as special counsel to the House Judiciary Committee from 2019 to 2020, including for the impeachment and trial of President Donald Trump. Before that, he served as the U.S. ambassador to the Czech Republic from 2011 to 2014. And before that, he was special counsel and special assistant to President Obama. And in that position, he earned the press's nickname Ethics Czar for his anti-corruption work in the White House. Ambassador Eisen and I are both lawyers. Professor Morris-Suzuki and I are both academics. And I also practice law actively. So we have a range of different related and overlapping perspectives that I'm very pleased we'll be able to bring together in this panel. All of us are actively writing and researching in our fields. This event came about in response to recent events involving the history of comfort women in the context of History Month and a year when violence against Asians and Asian women has become very salient. So I recently reported in The New Yorker on the Japanese historians in the United States and their responses to my colleague, Mark Ramsey, who published an article in a peer review journal claiming that Korean comfort women were not forced, coerced, and deceived into sexual servitude for the Japanese Imperial Army and confined under threat of violence. He denied that. He called that account pure fiction. And instead, he claimed that Korean comfort women chose prostitution and entered contracts to go work at warfront brothels. Purporting to use game theory and economic analysis, he said that the economic structure of the contracts, namely a high upfront payment, followed by a period of indentured servitude where the women would work off their debt by having sex with dozens of men a day for months or years, reflected that the sex work was voluntarily chosen by the women, not coerced and not forced. So this set off a controversy that was not merely academic, but could also potentially affect the diplomatic relations between Korea and Japan, and also the role played by the United States as their ally. My article in The New Yorker in late February, which was then translated into Korean and Japanese, chronicled what I found as I followed a number of historians and economists as they looked into the basis for the truth claims that Ramsey was making. And that opened up a set of reflections on how we should go about evaluating what is true in the academic community, as lawyers, as citizens of a democracy, particularly coming out of a year when we have battled what many have called the big lie about the 2020 election, and we have seen the dangers and the violence that emerged out of that. What the Japanese historians, including Professor Morris-Suzuki, found is that Ramsey's citations did not contain any sources that refer to Korean women's contracts, no secondary sources or third-party sources that described the terms of such contracts. And in an interview, Ramsey told me, "I don't have any Korean contracts. I thought it would be cool if we could get the contracts for Korean women, but I haven't been able to find it. Certainly you're not going to find it." That's what he told me. So while that does not demonstrate that contracts did not exist, perhaps they did, and the historians certainly would be open to that if there was evidence of it, it did raise questions about how a scholar, a writer, a researcher can make claims about the content, structure, meaning, or validity of contracts that one cannot examine or read about. The historians also found that often the sources Ramsey cited plainly said the opposite of what he used them for, including in one stark instance when he said that a 10-year-old Japanese girl who entered into prostitution, quote, "even at age 10, she knew what the job entailed," unquote, when her account in the cited source said that she didn't know in advance what the job entailed. And of course, even if contracts for comfort women were to have existed, another important component of truth is context, that in the context of war, colonialism, gendered relations, poverty, illiteracy, and other factors affecting the ability to understand what contracts might say, it would be unclear how their existence would indicate voluntariness on behalf of the women who were comfort women. So in early February, when I first mentioned this to Norman Eisen, I mentioned to him the argument that my colleague, Professor Ramsey, had made. He immediately responded to me by drawing my attention to work that he had done on Holocaust denial. And this brings us to what lies beyond the history of the comfort women, which is also the topic of this event. The lessons that we can glean from the ease with which claims that are not based in fact become accepted by some as truth or just plainly a difference of opinion. And that way, it can creep into academic articles, into classroom teaching of students, into domestic policy and international relations. Ambassador Eisen wrote about the connection between the denial of human rights violations and genocide, including the Holocaust, and what he has called democracy denial, coming out of the 2020 election, in which the distortion of truth and calling the other side's claims fiction can have consequences that we could hardly imagine possible in our country. Certainly, there is a spectrum of egregiousness in which people might say it's better or worse to deny one kind of thing than another kind of thing, one kind of atrocity than another kind of atrocity, the Holocaust versus sexual coercion and confinement of Asian women during the same World War by the Japanese army, or denying other forms of violence. But they all raise an alarm about a larger connection between what we can say we know to be true and how we proceed on the basis of that knowledge in how we treat other people and how we order our society and respect people's rights. I think our common cause, whether we are lawyers, historians, ethicists, diplomats, or academics, might rest on the importance of proper procedures for getting at the truth. And the idea that if we don't abide by the procedures, if we don't enforce them, if we don't speak out when they are violated, we are sunk. As participants of democracies that aim to respect human rights and dignity, and in a peaceful and honest relation between groups and between nations. I know that what I've said is a particularly lawyerly way to approach the question that is the topic of today's session by saying it's about procedures. But I am here also going to borrow from our historian panelist, Professor Morris-Suzuki, whom I recently quoted in the New Yorker, saying if there are no ground rules, then academic journals would have no basis for rejecting any paper submitted to them. And any statement of opinion, however lacking in logic or factual evidence, would have to be treated as equal to any other. We could then very easily end up spending much of the rest of our lives debating conspiracy theories or fake news, which have no intellectual foundation whatever. And then we might as well pack up and go home. So with that, I will cede the floor to Professor Morris-Suzuki to go a little bit deeper into the case of the comfort women and the recent debates that we have had.
Thank you so much. And it's a pleasure to be able to take part in this panel. I think the topic is such an important one. As I talk, I'm going to be showing some pictures, PowerPoint. This is really just to remind us who it is that we're really talking about here. In his article on the Comfort Women issue, Mark Ramsey quotes extracts from the memoirs of a comfort woman named Moon Ok-ju, and he uses those as evidence for his argument that comfort women were who signed contracts according to what he calls basic game theoretic principles of credible commitments. He also says that many of them were quite well paid and managed to go home quite wealthy. And he cites Moon Ok-ju as someone who seems to have done well most flamboyantly. he quoted look as though he's taken them out of her memoir. In fact, he hasn't. If you look at the footnote, you find that, like material that Professor Ramsey uses, it actually comes from a neo-nationalist anonymous online blog, which has strung together a few passages from Moon's memoirs to convey a particular impression that it wants to convey. Another researcher, Joshua Plser, who has actually read Moon's quotes other parts of her story. She describes being abducted by the military in Manchuria and taken by force to a station. She says how she struggled to win the affection of Japanese soldiers by learning to sing the Japanese songs that they liked. And because she was a skilled singer, they gave her tips, and that helped her to survive. Music helped her to survive. She recalled that on rare occasions when we had something to laugh about in our tortuous life, and when we felt lonesome or miserable, we would sing in unison or hum quietly together. So the history of the comfort women is both human and really complex. At least tens of thousands of women, maybe as many as 200,000, but we'll never really know the numbers, were trapped in Japanese military comfort stations during the war. They came from Japan, Korea, China, Malaya, Indonesia, the Philippines, or Papua New Guinea, the Netherlands, and other places. The ways in which they were recruited and transported and put to work were very varied. Those who survived and testified to their experiences described terrible sufferings during the war and often after the war as well. But some, of course, also describe moments of laughter or kindness, without which people, even in the direst of circumstances, wouldn't survive. So, criticism from Japan and Korea scholars, legal scholars, economists, and so on, which greeted the appearance of Ramsey's article, reflects the fact that Ramsey, in his standards of research quality and integrity in many ways. He completely ignores the recruitment of comfort women in places other than Japan and Korea. He fails to produce any existence of the contracts that he purports to analyze, as Jeannie Sukkerson just mentioned. He miscites documents, he cherry picks facts, he misrepresents the documents. More than 3,500 prominent economists have written a public letter of protest against the article, in which they say, we believe that this article goes well beyond academic failure or malpractice in its breach of academic standards, integrity, and ethics. The author is using economics, more specifically law and economics, as a cover to legitimize horrific atrocities. So how do we deal with something like that, an article like that, in an academic world whose lifeblood is free speech and the right to diverse opinions? That's a really vital one, particularly in this current age when fake news, as we know, is everywhere. And it's really important to say that this is not just one random bad article. It needs to be seen in the context of what I would call a much larger attack on historical integrity issue and about the history of the Pacific War as a whole, being driven by a range of Japan-based lobby groups with strong political connections. They have academic-sounding names and so on, but use methods devoid of academic integrity. And maybe we can come back to that in the discussion. But what I wanted to say now is that perhaps Ramsey's article is having one good consequence alongside its many bad consequences. It's making us think about this issue of academic integrity more closely and carefully. I think that in the hard sciences, the boundaries are a lot clearer. So, you know, scientists in areas like medicine and other hard scientists know that free speech and debate, of course, are crucial, but that doesn't mean that you can write an academic article that says that, herbal tea without experimental evidence that stands up to scrutiny. You can claim stuff on your Facebook account or your Twitter account, although maybe the COVID cure might. What you put on your Facebook or your Twitter account is not what you can publish as an academic in a peer-reviewed journal. There would be no point in doing any research at all, because any statement would be equal to any other. So why would you bother actually finding the facts? In the humanities and social sciences, things are a little bit more, and it's much more common to say that these problems of academic integrity are kind of over the importance of free speech. And there's a reason for that, and that is that in the humanities and social sciences, we do research differently. We rely on a range of different resources, documentary resources, and often oral testimony and so on as well. We combine those sources and rely much more on the interpretation of sources. So that raises a question, how do you distinguish debatable interpretation from deliberate misrepresentation? And how do you allow for human error? I mean, I'm sure I've got a footnote wrong occasionally, everybody does. How do you allow for our natural propensity to quote documents that support our argument a bit more than you quote documents that cast doubt on them? About this, since reading Professor Ramsey's articles, I think, already in academia, we do have quite a lot of clear rules for dealing with plagiarism, for example. We know what to do if you come across plagiarism. What we need to do is to develop rules that extend the ones that we have to deal with things like plagiarism. And as we do with something like plagiarism, we need to know what are the red flags, the signs that something has gone wrong here. And these include things like, existing research without proper explanation, failing to produce evidence for your research claims, misrepresenting the nature and the content of your sources, and all of those things. And then we need to look at how frequently that happens across an article or a series, and be able to make judgments and then, impose sanctions on people who do that. And obviously, it's not just a matter of imposing sanctions and preventing malpractice, but it's also a matter of academics to identify well-founded research and to distinguish it from sloppy scholarship and to distinguish those from deliberate, fake news. And that, I think, is just one of the most important academic skills. Professor Ramsey's articles also cast doubt on how the peer review process operates, and raise a really big question about how these ever got through a peer review process. And I'd be happy to talk a little bit more about that, because I think that's really important too. But I think I've probably talked for long enough now, so I'd like to hand over the floor and maybe come back to some of those issues later on in the discussion. Thank you very much.
Ambassador Eisen.
Thanks, Jeannie. Thanks, Tessa. I want to, before I begin, thank the National Coalition of Korean American Bar Associations, the representatives from CABA, DC, and San Diego who've spoken, the International Association of Korean Lawyers, the Korean American Association of Greater New York, and everyone who organized this panel and invited those to speak. And I must emphasize my gratitude to my friend and colleague, our moderator for today's panel, Professor Jeannie Suk-Gerson, not just for having me here, but for her leadership on the issues that we're addressing today, and also our fellow panelist, Professor Tessa Morris-Suzuki, for being here with us and the tremendous work she's done to expose the fabrications and falsehoods surrounding the misstatements generally about the comfort women. We're here today to discuss the importance of truth, comfort women, and beyond, and specifically the article by Professor Ramsey. I think my primary role here today is to cover the and beyond portion of the event's title. Of the three of us on the panel, I'm certainly the least expert on the specific issues surrounding the deeply concerning, and it seems to me, fundamental and disqualifying flaws in Ramsey's evidence in his article. Even a non-expert on the comfort women can peruse Professor Ramsey's writing and see at a glance that the, quote, game theoretical logic of credible commitments cannot justify the purported commitment of a 10-year-old, like 10-year-old Asaki, who Professor Sukerson spoke about, that Professor Ramsey initially relied upon in his article. What's worse, of course, is that upon scrutiny, the source showed that Osaki did not consent. Quite the opposite, she resisted. Despite Ramsey admitting error on this point, and despite the many other problems that that we've already touched upon on this panel, it seems that the article is going forward with publication. And that is, as Professor Morris-Suzuki pointed out, despite the many unfounded and wrong assertions in this scholarship that do not live up to the standards of the pursuit, the academic pursuit of truth. Perhaps the most shocking of the things in the article, as a practicing attorney, is not the wrong things it says, but the thing that is missing. As Jeannie pointed out, there is no primary or secondary or tertiary evidence of the contracts, the purportedly consensual agreements. The actual contracts themselves have not surfaced at all. And that is a core void that should be very telling with respect to this piece. My role today, as I said, is to offer some context around this issue of truth and denial, and to put it in the larger landscape of the battles over truth that are occurring in the United States and around the world today. I think one of the lessons of the age, I've learned this, I've observed this firsthand in my role as a CNN legal analyst, in seeing how the journalistic profession in the United States has transformed. From 4 years ago, great reluctance to call out lies when they're uttered by the most powerful people in the country, to saying as much, not just on television, but even in our most venerable journalistic institutions in print, the New York Times actually saying so when people lie. It's a reminder to me, I think, the lesson that journalism has learned, and it's one that the Academy is now going to need to pivot to, as Professor Morris-Suzuki pointed out. I was surprised when I went looking for Harvard Law School, my alma mater, Harvard Law School's standards of truth for evaluating scholarship by those on its faculty, that I could not find particularized standards. Perhaps that is because the academic authorities at the law school do not want to sit in judgment over the truth or falsity of their colleagues' utterances. But this larger battle over where are the limits of academic freedom and of, in the United States, the First Amendment protections, and even if something is not technically protected by the First Amendment, the value of freedom of speech, where are the outer boundaries, is something that we are now going to have to come to grips with. For me, one of the very painful lessons of the past 4 years is that you cannot take truth for granted. And that includes the truth that the Korean comfort women were victims of sexual enslavement by Japan. Of course they were. How awful that we would have to declare and defend that truth. It has a very personal resonance for me. I couldn't help but thinking of this as Professor Morris-Suzuki was describing the human reactions of the comfort women as they survived that enslavement, because as the child of a Holocaust survivor, an Auschwitz survivor, it brings to mind for me when I first came across the phenomenon of Holocaust revisionism in the 1980s. I grew up listening in horror to the stories of Jewish slave laborers, like my mother and her friends, and those few of her family who were lucky enough to survive, their stories of imprisonment, of the unimaginable cruelty of slave labor, the suffering of the death camps, and their narrow escape. Is incontrovertible historical truth, as is the fact that 6 million Jews, European Jews, perished. I was dumbstruck. I felt the same way as I did when Jeannie called me and told me about the Ramsey article, when I saw that anyone would claim, oh, things like the tenets of Holocaust revisionism false for those who've studied this. Oh no, Auschwitz was not a death camp. These were contract laborers. Of course there was some death, but it wasn't 6 million. Or there were no gas chambers at Auschwitz, the revisionists claim. People there died of natural causes, or any of the other outlandish and nonsensical claims espoused by those who deny the Holocaust and desecrate the memory of the millions who perished. Now we have a new form of denialism, comfort women denialism. Like with Holocaust denial, the claims fly in the face of the historical record. Like Holocaust denial, the claims are contrary to the great weight of the scholarly evidence. And like Holocaust denial, they defy belief and decency, fundamental decency. And yet there they are, daring you, requiring you to prove the opposite. It's a much, we've talked about 2 data points, but this is a much greater phenomenon, the assault on truth, whether it's the so-called Stop the Steal movement claiming that an election in the United States, the just passed presidential election, was stolen, despite the fact it was the safest and most secure, most successful election in our history, the climate denialism, the bizarre QAnon movement, the claim that with its claim that Jewish space lasers were behind the recent devastating forest fires in California, and on and on. The coronavirus vaccinations are supposedly a cover for Bill Gates to inject barcode. We are in a moment when truth is under assault. And so comfort women denialism is a piece of a much broader context. It's part of the reason, that's part of the reason that I'm so grateful to the sponsors of this event for their work, to the two professors for their efforts to call these claims into question, and for everyone who has risen up to critique this article. That's why I'm honored to stand with you to put this battle into the larger context in which we're fighting for truth everywhere, because truth cannot stand for itself unless we all stand with it. Thank you for inviting me to join you today.
Thank you so much, both Tessa and Norman. Those were great remarks that we'll use now to launch a discussion for a little bit before we turn to some audience questions. Both of us, both of you and all of us, are institutional actors. We are members of institutions. We have often led institutions. I mean, I'm sure, Tessa, you've probably chaired various institutional committees, and Norman, you have served in government, and you have served as an ambassador, serving the interests of the United States and representing in the international arena. I have a question about how all of this fits into institutions and how we should see the role. Tessa, you briefly mentioned Harvard, and also Norm, you did as well. Rules that institutions may have that may go to claims about truth and draw lines about what one is allowed to do and what one is not allowed to do. I have been very torn as an academic and as a lawyer who believes very strongly in the value of academic freedom, that it's got to have a very wide latitude, that and I think, Tessa, you believe this as well, free speech is the lifeblood, and academic freedom is the lifeblood of all that we as researchers rely on as we go into archives and sources and try to make arguments and innovate and try to see things that other people may not have seen as the truth. And so we do all of that. And on the other hand, we know that in an institution, there's got to be rules and boundaries about limits that you cannot reach. And so I just will put this open question to both of you about, in the academic context, of course, we have discipline. We know that academics can commit misconduct with their mouths and with their pens. That does happen. But we also have a sense that things, we've got to have the university in almost a neutral position to be able to say, you can deny the truth of certain things, and then the response should be other scholars, just as Tessa, you have done, and my colleagues at Harvard and other historians have done in response to Ramsey, that they've come back and said, no, this is what we found it to be the truth. And is this the process working the way it should, or is it not working the way it should? Taking the case of the comfort women and Ramsey as one example, and perhaps Ambassador Eisen, if you have views on what should happen if say a member of the Harvard Law School faculty said exactly those things about the Holocaust that you hypothesized would be absurd.
Well, there are, it's recognized, limits on academic freedom. And I think that the Holocaust deniers were the canary in the coal mine. I believe that if a member of the Harvard Law School faculty, published an article that said actually the 6 million Jews, this is a common claim of Holocaust deniers, 6 million Jews were not murdered in the Holocaust. It was only a handful. They died by natural causes. There was no intentionality. I think that there would be academic consequences for that. So I think we need to, I was stunned to find that there's no effort to impose consequences. We know that some of the lawyers, I'll take another example, that some of the attorneys who promoted Donald Trump's complete falsehoods and fabrications about the election, the big lie, it's another example of the big lie, that they are the subject of bar complaints, that it appears individuals have been forced out of law firms or academic institutions in connection with that. The exact circumstances are murky. It does look like there were consequences there. I don't think that hiding from the issue is the way to go. And I think there needs to be an effort to articulate standards. Of course, you need to balance, and you even need to err on the side of academic freedom, because that's the function of these institutions, and freedom of thought has driven the success of our global intellectual life. It's the driver, the principal driver of human progress. But we need to collectively articulate what the limits are, what the standards are, and then have experts apply those to articles with so many manifold flaws, like Professor Ramsey's, and then to assess, to assess intent.
Thanks very much. Can I come in also on this one? I think it's a really interesting question. And I too have been trying to look at what sort of rules and regulations exist in Harvard. It's difficult to tell, particularly as an outsider. My feeling is that it's quite a complicated system and the rules are not very clear. So I think that what needs to happen in Harvard is a very serious conversation about whether rules do already exist, which can deal with the problem raised by Ramsey's articles. And if they don't, then there needs to be a very serious discussion about how to create those rules for the future. And one of the reasons why I think it's so important is, having had some experience of trying to debate comfort women denial, it's a complete quagmire, because you go through somebody's work, you point out the flaws, you point out that the sources are miscited and they've completely misunderstood the evidence and all of those things. You put that out to the public, and the person that you're dealing with, and I've had this in the past, just comes back with a whole lot more invented sources. And it can go on forever, because they are playing by a completely different set of rules from the rules by which academic researchers and historians play. We need to be able to distinguish between, you can have all sorts of crackpot views in your private conversations, but in academic debate, then there have got to be boundaries, because otherwise debate just doesn't work and free speech doesn't work properly.
Well, yes. And so let me say a few more things about that. It's that, what does it mean for a scholar who has made these kinds of errors, of the kind that we see with Ramsey? What does it mean for such claims or such arguments or such authors to be, quote, held accountable? Because that's what I think a lot of students, it's a phrase that my students use all the time, the need to hold people or institutions accountable. And as an academic, I'm tempted to say, well, what being held accountable means is exactly what has been happening, which is that his colleagues, fellow historians and academics and economists have, thousands of them have looked at the work and actually criticized it very heavily and shown the work to be extremely flawed, bordering on what some of them would call fraud or misconduct. That has been happening, that has happened. Now, does that mean there's no accountability because we don't see the institution of Harvard University or Harvard Law School taking a stand and saying we distance or condemn, or in some way disciplining or doing something that's official? And that's the question that I'm often going around in circles with, because the kind of the beauty of the academic enterprise is that we are accountable to each other, that we are accountable to each other as scholars. And we know that anytime that we write something, our fellow scholars will scrutinize and tell us if we've got it wrong, and that there will be argument. And if there are objective errors, those will come out through the crucible of the academic criticism process. Now, sometimes it's just simply a difference of opinion. Sometimes if it's you might have interpreted something slightly wrongly or very wrongly, and other times it's something like this, where there aren't sources for the kind of arguments that you're trying to make. But and it's a spectrum. And so I have to say that and Norman, on the view of the lawyers who made arguments to the press about false claims about election fraud and the widespread nature of election fraud. Those are, and again, we have the same question. Are we talking about disbarment or discipline for such lawyers? Or is it accountability that courts just didn't buy them?
Disbarment has been sought, for example, against Sidney Powell jointly, it was quite extraordinary, I've written about it, jointly by the governor, the attorney general, and the secretary of state of Michigan, because of the harm that was done. And these lies led to, in their most extreme form, they led to the insurrection on January 6th, and they're continuing to do enormous harm in the form of the voter suppression bills that are now, like the one in Georgia, that are clearly motivated by a continuing commitment to that massive falsehood. So I am not prepared, as critical as I am, and I stand on the shoulders of the two of you, your expertise in criticizing the many, many flaws in Professor Ramsey's article, not to mention the larger context, the geopolitical context of distortions and fabrications by others, some even more outrageous than Professor Ramsey in this debate. But at a minimum, we need to say they're taking the example of Holocaust denial or the big election lie. There are some things that are outside the pale. Now, it is not an absolute protection, and there needs to be an effort to attempt to draw those lines. Academics should not be free to avoid that uncomfortable, in the same way that plagiarism would not be tolerated. There needs to be some line drawing here. I think it should be part of an academic code. I say that as a senior fellow at Brookings, which is an academic institution where we have rigorous peer review. There also was, it appears, a breakdown of the peer review process, as Professor Morris-Suzuki pointed out in her letter to the journal.
Thanks very much. Can I just come in on this one too?
Yes.
Yeah, I mean, I very much want to support what Ambassador Eisen has just said. I think a really important issue here is that this is not academics. So Ramsey's article has been taken up in Japan by this proliferation of neo-nationalist denialist groups. spread all over the internet, often with support from quite senior political figures as well. As you know, the Harvard expert said that these women were all prostitutes. And that's why I think it is really important for Harvard to be able to distance itself from this and to say, you know, whether it's not for me to prejudge what, you know, to be able to say that this is not something that Harvard accepts as research from its research community. There have actually been occasions in the past when historians within universities have faced investigations because their research was regarded as, you know, being based on flawed sources and so on. It's very rare. It hasn't happened very often. And I think, you know, again, it's difficult because the rules are so vague. But I do think it's very important for Harvard, in whatever way it can, to make clear that it, you know, this is not proper scholarship. And it raises issues of research integrity, but it also raises issues of research ethics.
I think that the plagiarism is an interesting comparison, because at Harvard Law School, we have had some very high-profile plagiarism accusations of our faculty, and none of them were, to my knowledge, disciplined or fired. And it's so when you compare that to what Ramsey is accused of, he would have some argument to say, hey, you didn't even fire people for plagiarism. How could you fire me or discipline me for doing something that is probably less clear cut in terms of being able to prove that there was, you know, wrongdoing here. So I think that the point still stands. I think the one that both of you are making, which is articulating academic integrity standards, has become newly in this era important in a way that perhaps in the past we could sort of look the other way. I think because of the dire consequences that we are aware of having this, having to debate absurd claims as if they were valid opinions, that we could just, you know, that there's a crucible of debate and then the truth will emerge. Well, sometimes that's not really the way it works. We have this ideal in our First Amendment culture, in our free speech culture, that the best antidote to a bad argument is to make a better argument. But a different model, I think, has to be fashioned for this era to account for the fact that we have basically people willing to play by different ground rules, as Tessa said, on what they claim are truth and facts, and then to change the argument on a dime. And a really good example of this is Sidney Powell being sued by Dominion for defamation, and then turning around and saying, "I made those claims, but no reasonable person could have thought that they were true." You know, so it's just there's no sort of like integrity. Literally, there's no integrity in how one approaches the statements that one makes. But I think these arguments in this era where you can go on Twitter and raise sort of speculations. You know, we have a faculty member who raised speculations on Twitter about election fraud, and students got really, really upset about that and saying that that wasn't within the bounds of academic freedom. But, you know, 4 years ago, could I have been someone who went on Twitter? I didn't, but, you know, could I have been someone who went on Twitter the night that Trump was elected and said something like, "Are you sure the Russians didn't hack into the voting machines?" I mean, I know that I got texts from lots of people who said that, who were liberals. So I think it's really difficult. And at some point, Tessa, perhaps we're going to be hanging on in this desperate way to the idea that scholarly articles are the place where you have to hold to certain standards versus Twitter and just kind of mouthing off. And then there's the question, I think, for the lawyers on this call, and you know, that our training, I know that our training has something to do with a problem that may affect the general culture and the legal community, which is that we very easily slide into arguments for our client. And this is, of course, the topic of your expertise, Norman, of legal ethics, of the borders and the boundaries of how far you can go to make arguments on behalf of the client, and this is where the historian's training is, I do think, very different from the lawyer's training, which is we do prize zealous advocacy, and it's not actually considered completely wrong for us to de-emphasize certain evidence and emphasize other evidence that helps the client. That's part of our obligation to the client. Not to tell untruths, of course, not to lie, but you know, the kind of thing where you look at evidence and you see kind of what you want to see, and you see less of what you don't want to see. That happens with lawyers all the time when they write briefs and make arguments in court. And then once you got that mentality, that training into the academic realm, I think legal academics are in a different ethical situation with respect to our prior norms than I think historians are.
Could I just come in also on the question of the peer review process, because we haven't really talked much about that yet. But I think that's the other area of standards that's really highlighted by this problem. And what seems to have happened, you know, why these articles, and it is a series of articles, were published in peer-reviewed journals, is because they kind of exploit a loophole in the system where in every case, Professor Ramsey has begun with a theoretical discussion of a particular theoretical issue. And then he cites the empirical material as a case study for the theory. And then the articles have gone to law and economics journals. And because of the kind of research silos that we have, I can only guess, I don't know for sure who reviewed them, but I can only guess that they were never reviewed by scholars who had the historical knowledge to judge the empirical content. And that's a huge problem that's shown up by these articles. And so I think we really need to talk about the peer review process. And it's quite a big discussion. I mean, it's about how we overcome the disciplinary silos, but also that I think the peer review process is tending to break down as academics are under pressure to publish more and have less and less time to actually do the reviewing properly. So there needs to be a really big discussion in that area as well, I think.
I hate to say it, but I suspect that this couldn't have been published in a journal of history, and it probably couldn't have been published even in a student. Tessa, you may not be aware that the legal profession, the academic profession, is generally dominated by academic journals that are led and edited 100% by students. And peer review, in fact, in our field is on the rare end of things, that we don't publish in peer review journals. We publish in journals where future lawyers, law students, are doing all the selecting of the articles and all of the editing of the articles, 100%. And I, the first thing I thought when I read the historian's account of how the sources say the opposite or they're missing sources is, this could never have happened with a student review journal, because those of us who've been on law reviews know that the thing that every student does on those journals is like check assiduously each source to make sure it says the thing that the text claims it says. And sometimes it's so tiresome and literalistic that as an academic, you just think, please give this a rest. But this is, this is the thing that it's good for, that there can be no possibility when it is done the way it's supposed to be done, that a source would be misrepresented to that great a degree, or that a claim would be made without some support that was plausible for it. And so in a way, it's the peer review, not only the breakdown of the peer review process, but the fact that it was peer review as opposed to the non-peer review situation that we are normally in as lawyers who publish academic articles. So I do think that that's something to think about, and whether peer review in the legal profession being as marginal a venue for publication is actually doing more harm than good in situations where there are actual factual claims, not just theoretical claims or theoretical, constructs that are being discussed. So one thing that I want to make sure, and I'm incorporating now already some of the questions that have been coming in. We're in an era right now where many academics are concerned about being disciplined for the things they say. And every day, as a lawyer who represents such academics, every day I get accounts of academics who come and say, I need a lawyer because my institution wants to investigate me for a statement that I made in class that some student found that didn't quite hit the mark in terms of their ideas about how I should be talking about this subject, or things that are seen as discrimination by certain students that that's what my claim is not discrimination, but rather academic freedom. So we're in an era where this is really a growing concern, and also some of Ramsey's defenders have outright come out and said this is cancel culture, right? You're trying to cancel Ramsey or cancel this kind of argument. So how do we deal with, or how should we think about the need to fight against the denial of truth, and yet also protect the feeling that people can have, whether it's on campus, in classrooms, or on CNN, or wherever one is expressing ideas, to be able to say, like, these are unpopular ideas that I do not, that people don't really like, or ideas that are debatable. Is this a complete red herring to even mention the cancel culture type of critique in this context?
Shall I go first?
Yes, go ahead, Norman.
I think we have to grapple with those issues as we've been grappling with them on the panel, not just in the particular cases. That would not be very judicial or Rawlsian of us to set the rules based on this example, but I think the three of us agree that there, at least Professor Morris-Suzuki and I agree, that there should be a set of standards, and then we'll see how the chips fall. I know, returning to the courtroom, that notwithstanding the latitude that you talked about, Jeannie, of lawyers to make the creative arguments on behalf of their clients, and we want them to stretch and to test the system, there is Rule 11. There are limits. There's a notion of ethically, where I apply my trade. There's a notion of candor, an ethical obligation. It's one of the most fundamental obligations, of candor to the tribunal. And I think, given the allegations that this was not a one-off issue, I haven't investigated the other papers, but the allegations that there's a pattern here, there does need to be an independent review. And Harvard is going to have to be comfortable with the possibility that it actually may get some people angrier than if it does nothing, if it conducts a review and determines that there were no standards in place, so it cannot sanction. But I think there has to be, in so many other places, whether it's ethics, the court, plagiarism, or otherwise, there are standards. And in this era that we've talked about of the denial of truth, there now need to be better academic standards as well. Otherwise, the risk that the entrusted power that comes with a named position at an eminent institution is susceptible of abuse, and that is a harm, even if you run some risk of empowering illegitimate allegations.
Yeah. So Tessa, do you want to say something?
Yeah. I mean, I'd just like to really support what Norman's just said. I think, having clearer rules also helps to identify what is not academic misconduct.
Mm-hmm.
So it may, it protects academics against the student who makes a claim because somebody has said something about history that student disagreed with and found offensive. And of course, I mean, having clearer rules, it doesn't make things completely simple. There are always going to be contests about the interpretations of the rules and, whether something falls one side or another. But carefully thought out, clearer rules will help to protect free speech just as much as it helps to protect against academic misconduct.
Yeah, so we have only a few minutes to go, so I want to read one thing from someone in the audience who says it is perfectly acceptable to cancel lies, and it is okay to cancel evil, and that was the whole point of World War II. So, very pithily expressed, but I think we all get the point. And it is possible that among the three of us, I am the only one who, breaks out in hives at the thought that an academic publishes an article and as a result is in danger of being fired. And regardless of how evil the article may be, or, how false it may be. And I think possibly it is also because I think that, I also publish a lot of things that may be seen as unpopular or that people may disagree with. And I don't plan to lie or make up sources or engage in any kind of misconduct or plagiarism or anything like that. That's not what this is. But the idea that an academic publishes an article, it gets all this international attention, people are outraged, and then as a result, he or she might be fired, that to me makes me break out in hives. And I wonder how you would respond.
My response, I think, would be, I absolutely understand where you're coming from, but I guess I see it a little bit differently, because I think that in academia, we always have had limits on freedom of speech, ultimately. So, if you plagiarize egregiously, if you take your PhD student's thesis and publish it as a book under your own name, mm-hmm. you would be likely to be fired. And I don't think anyone really has a problem with that. And if you were a scientist and you publish a whole series of papers that say that your experiments produce certain results when they didn't, we accept that that's also a situation where people might be fired. So I do think that the same, I mean, obviously the firing is the ultimate sanction. There might be lesser ones as well. But the same does apply in the humanities and social sciences. It should be a very rare occurrence. It should be very carefully considered and within a very clear framework of what does and doesn't constitute misconduct. But I think that it should be there ultimately as a potential sanction, just in the same way as plagiarism and scientific fraud sanctions are there.
And I would think, and Norm, maybe you could also maybe add to that just the same situation with lawyers, you know, lawyers lying to the public about things like about the election. I think we're going to have to deal with. We're going to have concrete cases that we're going to see decisions on.
It's a much more well-articulated standard, despite the fact that we have the epistemological gladiator in the arena, in a courtroom. Those are battles over what is the truth.
Yeah.
I think with a presumption for freedom of thought and freedom of speech, with a suitable independence and insulation built into the system, with a concept of peer review, with a notion that this is for only the most outrageous and extreme examples and patterns, and an idea that losing employment should apply only in the most severe of cases, with all those caveats to have some more definition around this, we are going to find that the battle over truth that I began my remarks with is creeping into the academy more and more. We have a lot of experience with this over Holocaust denialism. We can't ignore the questions about the political impact and possible political intent of these allegedly false statements. That needs to be taken into account as well, the purpose. So with all of those caveats, I'm agreeing with you, Jeannie. It should be we need very, very steep protections for academic speech, but it should not be. Speech is not unlimited. You might say that you need even more severe protections in the courtroom, where people's lives may be at stake, and you're going to inhibit an attorney from defending their client. If we can do it there in matters of life and death, of where fortunes and livelihoods may be at stake, I think we have to do it in the academy as well, just to establish those outermost boundaries.
Thank you, both of you, Tessa and Norman, for helping refine our thinking about this extremely important question. And I really am very grateful to both of you for joining us, and to the audience for participating with their questions and thoughts. And I will now turn things back over to Brian. Thank you.
Thank you very much, Professor Sue Gerson and Morris-Suzuki, and Ambassador Eisen, for your participation and insightful discussion and comments today. Thanks also to all 12 of the Korean American Bar Associations, the International Association of Korean Lawyers, and the Korean American Association of Greater New York for their support. A special thank you to the California Asian Pacific American Bar Association and Executive Director Charles Jung for sharing with us the video platform and running the tech today for today's program. And thank you to all of you for coming and asking such great questions, and for just being here. We hope you found this panel informative and inspiring as we all continue to fight the good fight for justice, for truth, and for peace. Thank you.